Good morning, everyone. Thank you so much for joining us for our training on anti-racist lawyering practices for pro bono attorneys. My name is Amira Samuel. I'm the Director of Pro Bono and Volunteers at the New York Legal Assistance Group, and I'm thrilled to have you here with us today.
Hi, good morning. My name is Sarah Harris. I am the Director of Outreach and Access to Justice Programs at NILAG.
Good morning. My name is Melissa Chua. I'm the Associate Director of the Immigrant Protection Unit here at NILAG.
Hi there. My name is Maya Gross, and I'm the Director of Training at NILAG.
Before we begin, I want to acknowledge the breadth of the material that we're covering. Many of these topics could be trainings on their own, and we want to acknowledge that there is so much more to be said, and we're touching really lightly on some things because they're really important factors in a conversation, but need further training to fully grasp a lot of these issues. Also, this is not a racial justice training. So we're talking about the work of acknowledging biases, working to eliminate them in ourselves and our client interactions, but we're not talking about the very important work of dismantling racist structures that create bias and oppression on a systemic level. That anti-racism training and work is important, and it's also not the focus of what we're doing today. We designed this training because providing representation with an anti-racist lens is an integral part of trauma-informed, client-centered lawyering. This is a primer on complex issues that could be covered in much greater depth. The concepts covered help to develop an anti-racist lens to use in pro bono lawyering. And this lens will support your conversations with clients, the development of your case theory, and your advocacy efforts. Anti-racist thinking is an imperative component of trauma-informed client-centered lawyering because facing racism continuously is traumatizing. Understanding the way our legal and social systems are rooted in racism and the way our clients experience racism within these systems is critical for systemic change. So the structure of this training is as follows. In part one, we'll talk about anti-racist principles and how they inform our analysis of the legal system. In part two, we'll discuss how to approach client-centered work with anti-racist principles. And in part three, we'll talk about how to disrupt racism through case strategy and advocacy. Part one, core anti-racist principles and how they inform the legal system. So for foundational background, over the course of the next hour, we're going to be talking about racism and structural racism, but we really can't do that without acknowledging the fact that our country was established on this land because of colonialism and white supremacy, and specifically the decimation of indigenous people and slavery. The wealth of our nation was built on the enslavement of Black people. When we say white supremacy, we mean the belief that white people are superior to non-white people and should therefore dominate society. In practice, white dominant culture is equated with what is normal and standard, and all other cultures are compared to that standard. White supremacy and white dominant culture result in political, institutional, and economic privilege, and other races and cultures are seen as abnormal, atypical, or perhaps inferior. A quote that really captures a lot of this is by Toni Morrison. In this country, American means white. Everyone else has to hyphenate. So client-centered and trauma-informed advocacy. As we've discussed, anti-racist lawyering is part of being client-centered and trauma-informed. So client-centered lawyering means providing individualized services and responses based on the needs and wishes of each individual client, respecting their self-determination and goals. Trauma-informed advocacy means understanding trauma and the varied ways trauma might manifest in your client's life. Trauma may be caused by events such as assault, war, housing, instability, financial instability, natural disasters, systemic violence, and racism. To be client-centered, we must be trauma-informed. Racism is traumatizing. Racism is a chronic trauma faced by our clients that impacts their decision-making and their goals, and we have to see that to be client-centered. The trauma of racism is a community trauma that crosses generations. It's impossible to bear witness on continued harms against people who you identify with without and not be impacted. Client-centered lawyering is anti-racist.
Before we jump into how anti-racism applies to our work representing clients, we want to first lay a foundation with 3 core principles that we feel we need to understand in order to approach lawyering with an anti-racist lens. I'll run through them here and then explore each further. The first is understand race as a social construct. The second is see racism systemically or structurally. And the third is engage in constant vigilant pursuit of anti-racist policies. One foundational concept is the understanding of race as a social construct. While we may inherit from American culture the belief that race is something you're born with and based on phenotype, such as skin color or facial features, in an anti-racist analysis, we see race as a social construct defined by social, historical, and political forces. Race is given social meaning, and those meanings have significant consequences in terms of how people are treated under the law by each other and how goods are distributed in society. But these social meanings of race are not fixed and permanent. They change over time and they depend on where you are. For example, in early US history, the category of white people did not include Jewish people of European descent or Irish people, who today would be considered white. And a person who might be categorized as Black in the US today might be considered white in Brazil. This is important because anti-racism sees the construction of race itself as a means of distributing resources and power. Race does not exist outside of or independent of these hierarchies of power. The second core principle is looking at racism and white supremacy systemically and structurally. The anti-racism approach is focused on structural or systemic racism rather than individual racism. The traditional or perhaps more commonly shared definition of racism focuses on the individual. So for example, I was taught that racism is prejudice, meaning discriminating against someone based on their race, and that prejudice by someone with power. And this definition usually assumes an intent to discriminate. However, from the anti-racism perspective, we look at how racism and white supremacy is embedded in the structure of systems, such as the criminal legal system, the immigration system, the healthcare system, and others. We are tuned to how the policies and norms of those systems create and reproduce racial inequities. We look at the history of those systems and see how each system assigned privileges to those seen in the category of white and applied disadvantages to those seen in the categories of color, such as Black or Asian or Latinx. The anti-racism perspective recognizes that systemic racism is not based on individual choice. Rather, it is deeply integrated into the fabric of our social structures. This is not to say that individual racism does not exist, and as lawyers, we need to be attuned to acts of individual racism. However, as lawyers representing clients who are impacted negatively by many of the systems I just mentioned and more, if we are anti-racist advocates, we need to be mindful of how the racism embedded in these systems is harming our clients and their communities. Now, why do we use the term anti-racist and how does it differ from the terms DEI? DEI focuses on making a space more diverse, welcoming, affirming, and fair for people of all backgrounds and identities. Anti-racism requires organizations to scrutinize and confront systemic racial bias that is endemic in society and to look within our workplace cultures, policies, and practices to identify and uproot racial biases and white supremacy. Anti-racism requires we acknowledge, question, and transform the ways that we've been conditioned to operate, and to dismantle the structures that maintain and perpetuate racist outcomes and impacts. As lawyers, we work within a legal system or legal systems that were built upon racism. So today we're focusing on how we acknowledge this truth and our position in and relationship to those systems, and what work we can do to correct the impacts of structural racism and call out the incidents of individual racism our clients encounter throughout the course of our advocacy with them. The third core principle is anti-racism requires constant, vigilant pursuit of anti-racist policies. One of the best known writers on anti-racism, Ibram Kendi, who wrote How to Be an Anti-Racist, wrote the following quotes on your screen. Racist and anti-racist are like peelable name tags that are placed and replaced based on what someone is doing or not doing, supporting or expressing in each moment. These are not permanent tattoos. No one becomes a racist or anti-racist. We can only strive to be one or the other. And being an anti-racist requires persistent self-awareness, constant self-criticism, and regular self-examination. Kendi believes that a person is acting in a racist manner when they support a racist policy by their actions or inactions. And racist policies are those that produce racial inequities. He says all policies are either racist or anti-racist. They either perpetuate racial inequality or dismantle it. So being an anti-racist requires us to always ask ourselves, are our actions supporting racial inequality or disrupting it? And then to be anti-racist, we must support policies that promote racial equity. Kendi also says that anti-racist work requires constant and vigilant self-awareness and effort. This is not an issue of attending one training and then you are done. This concept is further expressed here in this next slide by a metaphor crafted by Beverly Tatum, professor and scholar who writes about race and racism. Tatum says she visualizes the ongoing cycle of racism like a moving walkway at an airport. Active racist behavior is like walking quickly in the same direction that the walkway is moving. Passive racist behavior is standing still on the walkway, being moved along by it. But anti-racist behavior requires walking actively in the opposite direction at a speed faster than the moving walkway. This metaphor helps us to acknowledge how hard and uncomfortable anti-racist work is, because it requires us to identify and call out racist structures and policies that are built into the systems all around us. How does this moving walkway apply to us as lawyers and to the culture of lawyering? Well, think back to the acculturation that takes place during law school. We are taught that the law is neutral. This commitment to neutrality ingrains in us the habit of ignoring or not seeing the racism around us in all parts of the legal system. We are trained to make arguments that are devoid of race. And when we raise up discussions of race or racism, these are seen as emotional, biased, or not intellectually rigorous, and not black letter law. So we follow this habit and move along the walkway, silent about the racial injustices which we see all around us. And in practice, unless we are litigating a civil rights case, when we raise race in our legal arguments, there's palpable discomfort in the room. Anti-racist lawyering is pushing through this discomfort, running in the opposite direction of the moving walkway, and naming racism as we see it.
So what does anti-racism look like in practice? We must acknowledge the systems that we and our clients interact with are established to maintain this hierarchy. And as such, we must view the individual cases that we work with within the larger context of these racist institutions. So to give you a sense of how these systems are built on racist foundations and work to maintain hierarchy, we wanted to do a deeper dive into some of these institutions that you and your clients may be interacting with. So first, immigration. As we will discuss, the fundamental bases of immigration law were to uphold white supremacy through the exclusion and criminalization of others. As an initial matter, though, as Amira touched on in the beginning, it's worth noting the inherent injustice of immigrants to the United States, the colonizers in the land taken from indigenous people, then making laws to exclude other people from being able to immigrate to the United States. From the very beginning, immigration was built on open immigration for white people from Northern Europe and the exclusion and subordination of individuals from Africa, many of whom were forced migrants as slaves, Native Americans, Asian people, and eventually immigrants from other parts of the world. The very first uniform rules for naturalization already excluded vast numbers of people already in the United States based openly on race. So the Naturalization Act of 1790, these were the first uniform rules for naturalization, limited naturalization to, quote, free white persons of good character. After the Naturalization Act of 1790, which excluded enslaved people, indentured people, free Black people, and Chinese people, a number of laws were then enacted to exclude others based on race. For example, in 1795, the Page Act was passed, which barred entry for all Asian women. Later, the United States signed a treaty with China, encouraging Chinese nationals to come to the United States to work. And in response to the increasing numbers of Chinese nationals who were coming to the United States pursuant to that treaty, the federal government passed the Chinese Exclusion Act of 1882. The Chinese Exclusion Act of 1882 barred entry for all Chinese nationals. And this act was challenged many times and upheld by the Supreme Court in a series of cases, starting with Che Jianping, which was also known as the Chinese exclusion case. The Chinese exclusion cases were the seminal Supreme Court cases which established the federal government's power to regulate immigration, where Congress, quote, considers the presence of foreigners of a different race in this country and who will not assimilate with us to be dangerous to its peace and security. In the Chinese exclusion cases, the Supreme Court rooted the federal government's power to regulate immigration in part with national security, viewing the large numbers of Chinese immigrants who had come to the United States to work pursuant to the treaty that the United States had with China as an invasion by the vast hordes of Chinese people. Taken together, the Chinese exclusion cases suggest that foreign immigrants, even if they are civilians and even if they are legally admitted, are a military danger over which the federal government has total control, that the power to exclude them is so basic to our nationhood that the Constitution can't limit it, and that a restriction, even a total ban on any basis, is beyond question by the courts. And as such, despite the fact that the Chinese exclusion cases and their progeny upheld an openly racist law, the cases were never overruled and have created immunity for the government's racist treatment of disfavored groups of individuals. In addition, the idea that some immigrants, mainly non-white immigrants, are a threat to national security, they are criminals who would disrupt our way of life. This was the basis for the federal government's ability to regulate immigration and continues to inform the way that we treat some immigrants to the United States. Similarly, the treatment of immigrants as a faceless, dehumanized horde is also a concept that continues to carry through to the modern application of immigration law, allowing for overbroad, inhumane policies. After the Chinese exclusion cases, the federal government then passed the Immigration Acts of 1917 and 1924. These created Asiatic barred zones and banned immigrants from most of Asia. It also created a strict quota system that vastly favored immigrants from Northern and Western Europe. These national origin quotas stayed in place until the Civil Rights Movement and did not end until 1965. Notwithstanding the end of the race-based quota systems in 1965, these concepts that non-white immigrants present a security threat and are criminals who cannot assimilate persist. In 2017, then President Trump signed an executive order banning foreign nationals from 7 predominantly Muslim countries from entering the United States and suspending entry for all Syrian refugees indefinitely, citing again, as the Chinese exclusion cases did, national security concerns. In upholding the ban in Trump versus Hawaii, the Supreme Court, relying on cases citing back to the Chinese exclusion cases, upheld the government's broad power to limit immigration, where those immigrants themselves may be a threat to the United States, notwithstanding the racist implications of barring everyone from countries that were majority Muslim. Now, although many immigration laws are neutral on their face, they actually are applied in a racist manner. So in 2018, the Trump administration acted the zero tolerance policy, requiring the federal prosecution of asylum seekers, predominantly from Central and South America, leading to the separation of thousands of parents from their children. First, it's worth noting that the federal law used to prosecute individuals in these instances had themselves racist roots. The congressional history of the law documented the way that Congress invoked overt racism to justify the legislation at the time, discussing how, quote, the mixture blood of white, Native Americans, and Black people would inflict great penalty on the United States. They also said in the congressional records that Mexican nationals were, quote, illiterate, unclean, peonized masses who were poisoning American children. In addition, this dehumanized view of asylum seekers, primarily from Central and South America, as a horde of criminal invaders upon which inhumane treatment could be carried out, stood on the shoulders of the racist roots of immigration law to justify the treatment of immigrants decades later. More recently, the disparate treatment between asylum seekers from Central and South America as compared to those from Ukraine underscores the way that facially neutral immigration laws can still be applied in a racist manner. So recently, we've seen a number of asylum seekers from Venezuela as well as Ukraine. And initially, notwithstanding the COVID-era ban at the border, keeping hundreds of asylum seekers out, Ukrainian nationals were allowed access over the southern border immediately upon their arrival. And recent arrivals have been able to access benefits and temporary status. Compare this with Venezuelan arrivals who have not had any benefits made available to them, immigration or otherwise, and have been criminalized, monitored heavily by ICE, and placed into deportation proceedings. And finally, in a study done by Baji, we can see that people from Africa and the Caribbean are twice as likely to face deportation due to criminal conviction. They're more than 3 times as likely to be detained while their cases are pending, 6 times more likely to be sent to solitary confinement, and have the highest rates of asylum denials.
So I'm going to talk about the historical foundations of public assistance that are grounded in racism. But we're starting here with this image of the signing of the Personal Responsibility and Work Opportunity Reconciliation Act from 1996, which is a mouthful, because this act is what brought about our current iteration of public benefits. And it continues to be motivated by this very American belief that anyone who works hard enough will succeed. And thus, on the flip side, anyone not succeeding, anyone needing to rely on the system is not working hard enough and must be motivated to work. And these rules and the ones that came before it and continue to be implemented may appear race neutral, but we'll see in implementation and impact, they are built on and uphold the racist system. So starting way back in the early 1900s, the first benefit system came from these mothers' pensions that were supposed to support single mothers in needs. And these benefits were almost exclusively given to white mothers. Right from the start, these benefits had eligibility requirements separating out folks who were deserving poor, this ideal of who should get benefits and who needs to be motivated. The benefits often required showing that there was a suitable home, which was used to find non-white mothers ineligible. Then in the 1930s, the New Deal created the Aid to Dependent Children system in the Social Security Act. An actual language outlawing racial discrimination was removed from the bill, resulting in benefits being processed separately for white and non-white applicants. Again, requirements such as suitable work and employable mother standards were applied subjectively, with often childcare and homemaking work being found suitable for white mothers, but then employable mother standards being applied to Black mothers, non-white mothers, to deny them from benefits. The background of that discriminatory treatment was meant to discourage out of wedlock births, and it was fueled by this breeder stereotype that's also often been applied to Black women. Then also a separate benefit was created for the benefits of widows of retired workers. And this excluded occupations that were primarily filled by Black workers, making the benefit intentionally geared toward and then resultingly given to only white widows. That benefit did not have suitability tests and work requirements. And this tactic of purposely excluding certain occupations that were more likely to be held by workers of color continued throughout the years to affect wage and hour protections, affect who was eligible for unemployment benefits, making those workers more vulnerable to poverty and without any sort of safety net. Additionally, some states would pass farm policies which would cut off these public benefits, the aid through the aid-dependent children during planting and harvest seasons, to try to presumably coerce Black parents to work, even if there was no jobs available in agriculture. They would still set these standards to not allow benefits during these periods of time. So in the 1960s, there were already studies showing that families of color were receiving less in aid-dependent children, and that states with more people of color on the rolls were more restrictive with their benefits, which is unsurprising. But it was clear at that time. And meanwhile, policies such as the GI Bill were fueling prosperity for white people, while Black folks still faced racist barriers to prosperity, like through unemployment discrimination and housing discrimination through practices like redlining. Then in 1962, aid to dependent children changed to aid to families with dependent children, which allowed mothers of the children to receive aid as well as the children. And this then fueled that myth of the welfare queen, which was this idea that there were Black mothers out there exploiting the public benefits system through fraud and living in luxury off public benefits. And again, this is fueled by the racist stereotypes of non-white women and Black women being lazy, being breeders, having babies to stay on the welfare system. So the Personal Responsibility and Work Opportunity Reconciliation Act that we started with, it replaced the aid to families with dependent children and implemented the TANF system, which is what we have today. It wiped out federal eligibility rules and ended benefits as an entitlement, and instead implemented work requirements, penalties, harsher penalties for any sort of perceived fraud, and lifetime limits on receiving benefits. All in this sort of guise of we're encouraging people to work, and if they are able to stay on the rolls forever, they're never going to get themselves out of the system. The result, of course, was that more families that needed benefits eventually were not receiving the benefits. So as a result, fewer families in poverty have been able to access benefits. Back in 1996, 68 families received benefits for every 100 families in poverty. By 2019, that figure had dropped to 23. And in 14 states, it was 10 or less. Now, Black children have the greatest likelihood of living in states with the lowest benefits and with programs that reach the fewest families. So just as the first benefits systems were designed to do, the current benefit system continues to have a racist implementation and impact.
If we look back at the history of public housing, we find that it is inextricable from racism and prejudice. And this is our third example that we're going to look at. From Depression into the 1950s, when housing shortages were compounded by returning veterans, cities constructed public housing for white working and middle-class families located in all white neighborhoods and admitted very few Black residents. At the same time, cities built housing projects for low-income Black people in segregated, predominantly Black neighborhoods, or in places where they wanted to relocate Black communities. Federal housing policies also lured white families out of the projects into white suburbs, such as mortgage programs from the Federal Housing Administration or the Veterans Administration, which excluded Black families. FHA and VA guaranteed mortgages were so favorable that monthly carrying charges were often less than rents in the projects. The FHA required developers to include restrictive covenants prohibiting resale to African Americans, further cementing segregation. As whites fled the cities, Black tenants filled up public housing units further, which further segregated neighborhoods. In the ensuing years, there were also budget cuts to public housing, and the buildings aged without adequate funding for maintenance. Chronic underfunding for public housing has led to the poor apartment conditions we see today. Inadequate funding has created a backlog of unmet renovation needs. For example, a 2017 assessment found that the New York City Housing Authority, which administers 17% of the nation's public housing, faced $32 billion in capital needs over 5 years. Residents regularly complain about unsafe conditions, including peeling paint, leaky pipes, pest infestation, molding ceilings, and more. These poor housing conditions impact almost exclusively Black or Latinx tenants in New York City, as approximately 90% of NYCHA, New York City Housing Authority, heads of households are Black or Latinx. Part 2, how to approach client-centered work with anti-racist principles.
So we just presented very short summaries of the history of racism within just 3 systems that deeply impact our clients and clients you may work with. We see in this analysis that racism was not a byproduct or unfortunate collateral consequence, but rather that these systems were built upon a racist foundation, and that the history of inequality is inextricably woven into the policies and structures we see today. Being an anti-racist lawyer requires you to develop the habit of learning about and identifying the racism embedded in the systems that your client is interacting with. We want to acknowledge that as you develop this habit, you will see racism everywhere, and this can be overwhelming and may feel demoralizing. And yes, it is overwhelming and it can be demoralizing, but there's no way to fight the racism and become an anti-racist lawyer until you recognize it. So we train lawyers and advocates about client-centered lawyering skills, and one of our focus is practice and cultural humility, which requires us to focus on the client's experience. Understanding the history of the culture and systems the client, the legal system, and ourselves are operating in. And when we do these trainings, we talk about this framework of the 5 habits of cross-cultural lawyering. So I'm going to actually talk about just 2 of those habits in the context of anti-racist lawyering work as a framework to build anti-racist client communication skills, and understanding these histories of the racist systems in our clients' communities as part of using these habits. The first is going to give you insight into your relationship with the client and the systems. And the second is sort of an exercise to understand your bias and a practice to see different perspectives of where your client may be coming from. So the first habit that I'm going to talk about is in the structure of these 5 habits across cultural lawyering is called the 3 rings. And it's this practice to focus your shift from the status quo to confronting the racism that's present in the system and your client's experience, but also sort of acknowledging your own experience and your position within these systems. And so, one thing to acknowledge here is that you are also coming into this equation with your own set of experiences, your own possible traumas, your own daily experiences of racism or other types of oppression. And so when we look at using this three rings habit, traditionally it is to look at the relationship between your client, the law, and the yourself, the lawyer, and the law meaning sort of the whole system, the legal system. And I would say let's extend that exercise and look at how the law, the legal system, and maybe also all of the administrative systems that our clients interact with, and just structural systems such as housing that they interact with, and ourselves interact and are impacted by systematic structural racism, and maybe also individual incidents of racism they may experience. So when we are looking at this relationship, one thing to acknowledge is that we as lawyers and legal advocates are upholding some of these parts of the system that are racist. We have to work within a structure that exists already. We are working with the laws that exist. We can't make up new laws as much as we may want to sometimes. We can't change the system that is there. And so in order for us to be strong advocates for our client and build a relationship with our client, we have to be aware that we are part of that system, and that it is our job to call out the racism we may see, to acknowledge it to our client when we can't change it or when we cannot call it out, and to be the force to ameliorate that experience for our client, to help them through that, and to understand that their experience with us is both as their advocate, but also as someone who is part of that system. So the next habit that I'm going to talk about is a practice that we call parallel universe thinking, that is this way of exercising it's like a mental exercise to understand more about where your client is coming from, where disconnects in your communication may be occurring, or the experience of when you are feeling like, I don't understand what my client is doing, why they're making certain decisions, why will they not take a certain strategy approach. This is a way to step back and think, do this exercise and think, what are the aspects impacting my client that may be impacting their decision-making process, their lived experience. So our own biases might be consistent with biases baked into historically racist systems, and we have to explore that while we do this. And part of the exercise really is to examine our own bias and put them aside and look for other interpretations of what's going on with your client, trusting the client, and then examining what is going on with the client and what their experience may be. So just as an example, to help you wrap your mind around this, say we're working with a client together, and our client needs to get a medical exam. They need to go to the doctor as part of our case, that they have to get a report from a doctor. And we have asked them, please make this appointment. And they say, yes, I'm going to go do it. And we meet with them again, and they haven't done it. Please, this is the next step in your case, but before we can move forward, you need to do this. And they seem very resistant to it. They keep missing the appointment, or not making the appointment, making excuses. And we are just, you're getting more and more frustrated. What is happening here? Why are they not taking their case seriously? So we want to step back and look at what could be going on. A simple task like making an appointment for the doctor, going in, getting a routine examination may seem very straightforward. It may not for all of us, and maybe we are coming with lived experiences where we can immediately step in and see that when you are engaging with the medical system, you may be at the very first point of engagement experiencing racist experiences in a racist system. We know from studies that people of color are less likely to have their health concerns taken seriously. They may be immediately treated with a different level of respect when they walk into a doctor's office. There may be cultural expectations or weight given to certain types of doctors or certain types of types of diagnoses that come with shame. So there are a million different variables that may be impacting this decision, and a lot of those are strongly influenced by the structural racist history of the medical profession. And just us simply saying you have to get this doctor's report is not as simple as it may seem at the outset. And so if we can look at that, step into that experience, then we may be able to have a more well-rounded conversation with our client to see what is going on, what is the barrier here, what are their fears, can we talk through that and set up a plan so that they feel empowered to go take this next step without the fear that that the experience is going to lead to a certain outcome or go a certain way. So when we talk about anti-racist communication, client communication, just a few notes on like why we talk about it and best practices for anti-racist client communication. So the first thing the reason why we are talking about this is that, and you can go to the next slide, is that it helps you to understand your client's perspective, as we sort of just discussed using parallel universe thinking, this 3 rings exercise. It's going to help you be a better advocate. You are able to understand a more holistic perspective of what your client's experience is, but you're also going to see areas where your client's case may be being looked at in a through a racially impacted way that you can call out, that you can make a change in the way that the case is being handled or the decision is being made. And then an important note here is that this is your homework to do. This is not your client's homework. And what I mean by that is, this background work, doing this training today, learning about the history of these systems, this is your work to do, not to go into the client's client meeting and say, like, let's talk about the racism you experience. I want you to teach me. They're not there to teach you. This will help you have the conversation if they want to have it. It will help you call out the racism when you see it. But it will also help you just do the work silently if that's what needs to happen, and let the client live their life.
So to further connect what we talked about in part 1 and what it means to be trauma-informed and client-centered, we'll connect a few dots. So in part 1, we saw examples of the ways in which the law has been used to create and maintain hierarchies and power imbalances that are currently impacting our clients' realities and their legal needs. So in practice, these histories translate into fair hearings on food assistance. They translate into housing cases on untenable living conditions and removal defense cases. And all of this is really traumatizing. If we go back to some of the earliest slides in this presentation, we talked about this being an intergenerational impact. And our clients are often swimming in a pool of continuously experiencing the impact of these racist policies. So centering our clients and using an anti-racist lens to understand their engagement with these systems better positions us to advocate, because it helps us to build rapport with them. And that's imperative for presenting the best possible case. And it positions us to make arguments and preserve a record that calls out biases and advances decisions that are more fair. To practice trauma-informed client-centered lawyering, we have to acknowledge that our clients have experienced racism within the very system that we are requiring them to engage with to have their basic needs and safety addressed. Re-traumatization is a built-in component of the adjudication of their case. It's a continuation of that ongoing trauma. And racism is considered a fundamental cause of adverse health outcomes. So it's the impact isn't just in the immediate issue that you may be addressing with them, but in the totality of their lives. So understanding our role within the system. As legal actors, we are a part of the system that's been harmful to our clients and that our clients likely continue to view as unjust. This is especially true when we refer our clients out for supportive services and they experience those systems as further limiting their supports. It's not uncommon for our clients to have a difficult time trusting us because they have a difficult time trusting the system, or simply have no faith in it. So one thing that we can do is acknowledge to our clients that we understand that the system is problematic. We can be critical of the system while we're working within it. We can provide a lot of context on what's going to happen, what the space will look like, what the judicial temperament might be, what adverse arguments may sound like in preparation of that, and to also say we're critical of this even as we work within it. Part 3, how to disrupt racism through case strategy and advocacy. So look for opportunities to disrupt racism. Historically, lawyers for indigent clients have not identified racism and its impact on clients' legal cases. We worry about the risk of alienating other legal actors and harming our client's case. To be frank, I'm here today meaningfully engaged in this work, and I've never raised my hand in court and said, objection, racist. And that's probably not happening for you either. So how do we do that work? Anti-racist practice is to identify when racism and racist judgments are arising in our cases and consider strategically how to call this out with opposing counsel, with judges, and with other legal actors.
One opportunity to disrupt racism in our advocacy is to break the silence around the racialized context in our clients' cases. This relates back to the point we made earlier about the notion or fiction that the law is neutral. In her article on professionalism as a racial construct, legal services practitioner Leah Goodrich talks about how law school trains us to think about the, quote, reasonable person standard as raceless and genderless. And she says that stripping identity from the reasonable person standard means that whiteness becomes the norm. She points out that race, or the role it plays, is rarely emphasized in her practice area, which is housing cases or low-income tenant cases, even in a practice where people of color comprise the majority of tenants facing eviction, due to the effects of gentrification and systemic racism. So she advocates that we acknowledge the role of racism in our clients' lives and cases. She offers us in the article the following example from one of her cases, which is on your screen. Respondent is Chinese American and lives in the Soho section of New York. The area has historically been comprised of 70% Asian American and Pacific Islanders. However, in the last decade, that population has drastically declined due to gentrification, redlining, and displacement. This eviction case is not divorced from that. Respondent would like to remain in her community. Leah Goodrich suggests that we can break the silence around race and racism and acknowledge out loud that the history of racism within systems matters and is part of the story we tell about our clients and why they should get the relief we seek.
So work to call out racist presumptions in court. Examine the presumptions being made by adjudicators, opposing counsel, and yourselves. Utilize parallel universe thinking to examine your own biases, as well as the adjudicators and opposing counsel. So ask yourself, for example, why might your client have a real fear or discomfort of the institutions you are dealing with? Why might they be visibly uncomfortable interacting with different aspects of those institutions? Ask yourself why a judge or a court might treat your client as, for example, dangerous? Is this based on racist presumptions about the nature of your client? Is it because of presumptions baked into the law? And so do your homework. Work to call out those racist presumptions both to yourself and to your clients. And so, for example, immigration law sometimes requires an individual who's had some contact with law enforcement to apologize, to be the good immigrant in order to earn their benefit, even though we know that an encounter with law enforcement may be the outcome of over-policing or over-criminalization due to racism. One anti-racist way of approaching this would be to be transparent about the fact that the law requires your client to do this and is racist, but shift the power to your client to choose how they interact with this law. You can acknowledge here also the strain and trauma of having to play into these racist tropes as required by the process. And in addition, this is when it would be powerful, as Amira and Sarah touched on earlier, to remember your own role in the system. Acknowledge to yourself and to ourselves that forcing our client to play the role of a deserving immigrant is perpetuating the racism that's baked into the law and into these institutions. You can also challenge decision makers to examine those presumptions. So for example, remember the federal law that we discussed earlier that was being used extensively during the family separation crisis and was motivated by racist tropes and a fear of invasion by non-white immigrants. Some federal defenders who were arguing those cases invoked the racist history of the law itself to place squarely before the court the history of the law and that the law that they were applying and how it was designed specifically to target Latino immigrants seeking to enter or seek asylum at the border. This is an example of one case that we worked on with pro bono. So Ms. D seeking asylum after being forced to undergo FGM in her own country. And in her hearing, the immigration judge demanded that she prove that she did not force her own children to undergo FGM as well, which would have barred her from asylum for being a persecutor. However, the law requires a prima facie showing on the record that someone is persecuted before undertaking a more in-depth inquiry, and no such objective proof existed. And on analysis and reflection, it was really clear that the immigration judge had made a presumption that the client was a persecutor simply because of her race and her ethnicity. And in this case, the pro bono counsel engaged in the analysis necessary to see that this presumption was motivated by race and advocated that the immigration judge identify specifically on the record what objective proof existed that would warrant the further inquiry, which they were only able to do after really examining the presumptions being made by the adjudicator and opposing counsel. So in short, some tips on calling out some racist presumptions in court. So examine your case and the presumptions being made and the questions that may be posed ahead of time for potential issues. And call out those presumptions. Rely on your nonprofit partners for arguments, framing, and for strategy, and talk it out. In addition to integrating it into your oral advocacy, integrate these arguments into your written advocacy. Integrate arguments into complaints, motions, appeals, and other post-hearing briefs. And remember the moving walkway. It's not always, it may not always feel comfortable to call out racism when we see it. And it may feel like something we are not supposed to do when we're walking against the moving walkway. However, when you lawyer with anti-racism, you can provide powerful client-centered advocacy.
So we covered a lot of ground in this presentation. So we're going to talk here about takeaway points. And to help you walk away with a few tangible how-tos, here are 5 points. The first 2 are educational and mental shifts. The second 3, or the latter 3, are practical changes to your practice. Number 1, ground yourself in principles. Ground yourself in the 3 anti-racist principles we mentioned up front. Spend time reading about these and reflect critically on how these points impact your life and your work. Number 2, know the history of racist systems. You want to spend time learning about the history of the racist systems that you interact with within your specialized area of practice. Start with the understanding that racism is ingrained in all of the systems our clients interact with, and that we need to do the work to learn these histories since they were not taught to us as part of our training as lawyers, and even before that, as students in history class. Number 3 is apply anti-racist principles to your relationships with clients. This means understanding that clients might see us as part of oppressive systems, and that we need to use tools to establish trust and to convince clients that we too are critical of these systems, and that we believe them, and that we will elevate their story and support what is most important to them. Number 4 is bring an analysis of race into the story you tell about your client. Number 5 is identify and uncover racist presumptions by legal actors you interact with. Use your legal services supervisor to strategize when and how to do that. So in sum, we recognize that this reframing of our work takes commitment, effort, some likely discomfort, and a big dose of courage. This is not easy. So we suggest you look for community with other anti-racist lawyers to collaborate and strategize with. At NILAG, we are committed to this work and we are here for you. Thank you.
I see a question in our question box here. I'll read it off. So the question says, a little confused about something. If race is not based on phenotype, then how are those immigration laws examples of racism? And I think what this question is getting to is sort of like understanding what we mean by race being a construct, and not that race doesn't exist, right? But and I will try to answer this, and then please, Maya and Amir and Melissa chime in if you think I'm missing stuff. But it's not that race doesn't exist in our society. It's that we have to understand that race is not a unmoving thing, that it is a construct that includes phenotype, but it also includes this this hierarchical perception that it was that the way that we view race, the way we experience race, the way race has been built into our American society is a certain construct, and it is different than the construct of race in other places, and that each individual's concept or construct of race, it does fluctuate, and it fluctuates over time. So I think it is very important to take away, not that we're saying there's no race, or that you should leave saying like race doesn't exist. It's that race does exist for everybody, but it is something that as a society, we have created to be a certain thing that is based on a history of experience of oppression and a whole history of oppressive events and structures that have now been built into what race is. So when we talk about racism, we talk about people's race in those systems and how those systems of power respond to this construct of race for that individual. So if the person's nationality or race is being looked at in a certain way to make a decision that is based on a racist law or racist structure, then they are taking that construct and they are using it to further these racist policies, racist laws, racist structures. Does anyone have anything to add to that?
I think that's perfect, Sarah. I'll just sum it up by saying, while race is something that we all act upon as if it is a fixed, biologically, hereditarily determined thing, some of the examples that we've given indicate that it is not fixed and biological, that it changes over time and it changes where you are.
Please feel free to reach out to us at the New York Legal Assistance Group for more resources, for further learning, And of course, to join us in our pro bono efforts, helping New Yorkers in crisis and or experiencing poverty to use the power of the law to live their lives safely and with dignity. Thank you so much for spending the morning with us.